2 weeks ago, I made a video discussing a muzzle brake that had been designated by the ATF as a silencer, just a muzzle brake. Customers who purchased several different models of Lethal Eye, that was the brand name, muzzle brakes received letters in the mail from the ATF informing them that they faced up to 10 years in federal pound-you-in-the-ass prison if they didn't contact the ATF to discuss a surrender of the so-called muzzle brakes from Lethal Eye. This raised a lot of questions from you in the comments that if a muzzle brake can be declared as a silencer, then how do we know which muzzle brakes are silencers? How do we know that anything is or isn't a silencer under the ATF's broad definition of what constitutes a silencer? Is a potato a silencer? We're going to talk about exactly that today. As I mentioned in the video 2 weeks ago, I'm actually in pre-litigation with this exact issue with the ATF as we speak on behalf of one of my clients. So the topic is on my mind. Of course, the entire thing is a joke. In many countries, including countries with much more restrictive gun laws than the United States, silencers can be purchased over the counter without any paperwork at all. Other countries that are, again, more restrictive than the US, you have silencers being treated not differently than buying like a hunting rifle, meaning you can just walk in, buy your suppressor, walk out from the store with it the same day. Despite the United States having some of the most liberal gun laws in the entire world, and by liberal I mean free, of course, we curiously have some of the most ridiculous and arbitrary restrictions and hoops to jump through on silencers. The more shit and hoops you have to jump through in between, the more complicated the answer becomes, and that's where we are today in the United States and why I'm making this video. The good news here is that I can go on and on and on about the history of the NFA and its relationship with suppressors and why things are the way they are today, but I don't need to, because there are basically two really good court decisions that do a good job of talking about what a suppressor is and what a suppressor isn't. Let's start with the bad news first. This is one where we took an L and courts found that just one single part could be a silencer. In Sig Sauer versus BATFE, Sig sues the ATF to dispute a ruling by the Bureau finding that muzzle brakes welded onto Sig MPX barrels were silencers. Short version, Sig cleverly came up with this idea where they would take short-barreled MPXs, they would weld 9mm baffle stacks or monocores to the end of the barrels, making the length of the barrel 16 inches, therefore not short-barreled rifles under the NFA. If I remember correctly, there may have actually been a plan where Sig was maybe going to sell conversion kits that would allow the owners to convert the MPX muzzle brakes that were suppressor monocores into suppressors by putting a sleeve over them. This made things extremely tricky for Sig under the definition of firearm silencer that's applied by the courts because Sig flat out admitted, hey man, we're using suppressor baffle stacks or monocores as brakes on these guns. According to the National Firearms Act and the Gun Control Act, a silencer is defined as any device designed for silencing, muffling, or diminishing the report of a firearm. Okay, I mean, that's pretty clear, right? However, the definition also addresses parts and combinations of parts. Any combination of parts intended for assembly into a silencer, or when you have just one part. The test is whether that part is intended only for the assembly of a silencer. The government has the burden to show that a part or parts combination has the purpose to be made into a silencer, and courts have held that the test is more rigorous the fewer parts there are. For example, it's easier for the government to show that an illegally built silencer or something like a solvent trap is actually an illegal silencer. That's easier than it is for them to prove that just a thread adapter is a silencer. So how do you determine what's intended for assembly into a silencer? That's where things get tricky. Because you were talking about just one part in the Sig case, Sig had the lowest bar to clear. They just had to show that the MPX brake was not intended only to fabricate a silencer, but they failed. The court pointed to 4 different factors in holding that the MPX brake was actually an illegal silencer part. 1, it was literally a baffle monocore from a Sig silencer. 2, and this is funny to me, ATF said PCCs don't really need muzzle brakes. They're not that hard recoiling. 3, even if they did need muzzle brakes, the Sig muzzle brake was shitty and didn't really work that well as a brake. And 4th, kind of related to the last point, the Sig brake didn't look like any other muzzle brake on the market that actually was functional. Sig said that their brake worked as a brake because of the weight. Got to give it to the ATF on this one. They had a clever retort. They said, look, The weight of this brake means that it could work as a doorstop too, but that doesn't make it a doorstop. Thus, the court held that the Sig baffle brake, the baffle monocore that was on the end of the MPX, was in fact a silencer because its only purpose was to be used as a part in a silencer, no other purpose at all, therefore silencer. Before we get to the second case, which I like much more, this Sig case answers a common question from the last video. Why aren't quick disconnect muzzle brakes designed specifically for attaching silencers considered silencers, or threaded barrels? One, even if the primary function of the muzzle brake would be to serve as a mounting point for a silencer, but it doesn't itself, the brake, reduce noise, or include components specifically intended to reduce noise or be used in a silencer like the MPX brake did, it's not a silencer part. You also look at purpose. If it also functions as a flash hider or a muzzle brake or a thread adapter for attaching muzzle brakes or flash hiders, it's not intended only for use as a silencer part. Now the gray area here, the fun part, oil filter adapters. How are those different than a threaded barrel? Perhaps because their only conceivable use is to attach an oil filter to make an illegal silencer. But what if, bear with me here, someone makes a true muzzle brake or flash hider that will also accommodate an oil filter? I think that's still a loser just because the ATF simply would not allow that to happen. But on the law, if it's just one individual part and it serves some other purpose, it might not be considered a silencer part. I'll let you guys try it out. I'll sit here and watch. Okay, what's not considered a silencer? That's covered in US v. Crooker, a case I like better. Crooker, pretty based, habitual line stepper. You can tell he definitely didn't pick up his dog's shit whenever he walked it in the morning. He got the government's attention by illegally shipping nitric acid through the mail. Nitric acid used to make explosives, but isn't illegal to own. You just can't drop it in the mailbox and send it to your buddies. The Fed seized a package Crooker was mailing which didn't contain chemicals, although they expected chemicals in there. They found an air gun fitted with a silencer. The government raids his home with a warrant. They find an article that he wrote under a false name where he discussed the benefits of air gun silencers because they aren't legally considered silencers if they're made for air guns, but they can be converted easily to work on regular firearms. Testing his theory, the ATF used a thread adapter to fit Crooker's air gun silencer onto a .22 pistol. Lo and behold, it worked actually quite well as a silencer. The court, who called Crooker no good to society and indifferent to the law, still acquitted him. Why? Because the court said that this test isn't whether an item's capable of suppressing a firearm, but whether it's intended to suppress a firearm. The court specifically said that using that logic, potatoes or soda bottles could be silencers. And that's even if the owner of the device or potato or whatever was aware that he could convert it to use as a silencer like Crooker did. The court said that just because it's capable to be used as a silencer, even if you know it can be used as a silencer, that's not sufficient to make something a silencer. If the device was created for a different use, in this case, to silence an air gun, and it requires some modification or adaptation to fit a regular firearm, as this did, a thread adapter, now it's not a silencer. Funny enough, one of the things that helped Crooker's case here is that he wasn't caught with a gun. He was a convicted felon. He was smarter than that. He knew better than to have a gun. Instead, this guy dabbled with air guns that were almost as powerful as like a rimfire handgun, and thus totally legal for him, a convicted felon, to possess, so he had suppressors for him. The Court of Appeals logic, excellent in this case. They observed, and I quote, "The range of physical objects that can muffle a firearm is so large and of so many alternative uses that some filtering restriction is needed to prevent overbreadth and possibly vagueness." Overbreadth, vagueness, those words are very important because if a criminal statute is vague or overbroad, it's probably an unconstitutional law. Now, is everything clear? Do you know what is and isn't a suppressor now? Yeah, I didn't think so. I don't really either. But I hope it's clearer now than it was before. Remember, I'm not your lawyer. This is not legal advice. Thanks, guys, for watching. Appreciate you. Take care.